Welcome to our panel discussion on the rule of law in the European Union. I'm Kerry Colanisi, the director of the Penn Program on Regulation here at the University of Pennsylvania. And the program is pleased to sponsor this panel with my colleague, Nason Mahboubi, who has organized it and will moderate it. I simply want to offer my words of welcome and of emphasis on how important today's topic is. The rule of law is facing serious challenges around the world, including in Europe. There is the rise of populism and nationalism. Some populist leaders have abandoned the core rule of law principles. Others have acted to undermine them. Sometimes, just as populist leaders have made outsiders, whether migrants or minority communities, a scapegoat for society's woes, populist leaders have even made the law a scapegoat too. So I want to thank Nason for organizing this important session, and I want to thank all of the distinguished members of the panel, Francesca, Giacinto, Peter, Fernanda, for your participation. Let me also offer a special word of thanks to Giacinto della Cananea, who is spending the week visiting with us at the University of Pennsylvania. Not only are we so grateful to have this opportunity to spend time with you, Giacinto, but we want to thank you for giving us the occasion for organizing a comparative administrative law workshop later this week, which Nason has also organized and will bring together not only the panel members, but other leading comparativists and administrative law scholars. And we're grateful, of course, also to Perry Worldhouse here at Penn for helping us with Giacinto's visit and with the workshop. With that, and again, with thanks to all the panel members, as well as to our outstanding team here at Penn for making this gathering possible, let me turn things over to Nason, who will moderate what I'm sure will be a very insightful and I know will be a very important conversation. Nason?
Thank you very much, Kerry, and thank you to you and to Andy Coopersmith, the Managing Director of your program on regulation, and to the law school, Anna Gavin, for helping to put together this webinar today. It's tremendously exciting to be able to feature Giacinto della Cananea during his visit to the University of Pennsylvania, along with these outstanding experts. And it's very exciting that we'll also be able to meet in person at the end of the week with a number of the people that I see also in our participants list for this webinar today. So it's all very exciting, and a huge thanks to you, Kerry, Andy, and the rest of the team, Anna, for allowing us to have this platform to talk about these important issues. Let's jump into it. I'd love to invite the panelists to join me here so that I can introduce them to all of you, and then we can begin our conversation. These are really some of the best and most interesting experts on European law that one could find anywhere. Professor Francesca Bignami is the Leroy Sorensen Merrifield Research Professor of Law at the George Washington Law School. Giacinto della Cananea is Professor of Law at Bocconi University in Milan, where he is also one of the co-principal investigators of the project Common Core of European Administrative Law. Peter Linseth is the Olympiad S. Jaffe Professor of International and Comparative Law at the University of Connecticut School of Law, where he's also the Director of Graduate and International Programs. And Fernanda Nicola is Professor of Law at American University Washington College of Law, where she's the Director of the Program on International Organizations, Law, and Development. It's so great to see all of you here virtually today and to see you in person later this week. As we enter into this conversation, a word to this wonderful audience I see assembled. We're going to talk probably for about 45 minutes or so on the group that you see here, but then we're very much eager to incorporate as many of your questions into the conversation as we can. For that, I'll ask you to use the Q&A function, and I'll be curating those once we get to that stage. And the other thing I'd like to just underscore, which I think probably everyone knows, but I think it's important to mention, is that I am not a European law expert. I'm very interested in European law. I'm learning more about it, but I'm not a European law expert. I'm an expert more on Chinese administrative law. So I will be posing these questions to the group here as, let's say, a relatively intelligent but not expert interlocutor. And at least some of the people in the audience will also be in that category So we will try to have a conversation that will both appeal to the true experts who I also see in the audience, but also some of those like myself who are very interested to learn more. Okay, so enough housekeeping, let's jump into it. Let's first start by outlining what were the kinds of challenges to the European legal order that have arisen in recent years, perhaps especially from countries like Hungary and Poland. Perhaps I could invite Fernanda to initially say a few words about that, just a table set for the rest of our conversation. What is the landscape of challenge out of which these new policy responses that we'll be talking about have emerged? Fernanda?
Sure. Thank you, Nathan, for organizing all these, and Carrie for bringing us together. Let me start with what you just asked and give you a bit of a background. As we all know, the European community that dates back to the 50s as an experiment for economic integration, but it then solidified in the 90s as a European Union aiming to provide not only peace and prosperity, but also commitment to democracy and the respect of liberal constitutional values such as dignity, freedom, human rights, respect of minority, and of course the rule of law. But the 90s also represented a moment of transition in Europe, in which post-communist countries applied to enter the Union, waited until 2004, when the Commission assessed through the so-called Copenhagen criteria of whether these countries had a political and legal system compatible with the rule of law enshrined in the treaty Article 2, which is our kind of big Bill of Rights, if you like, or that enshrines the values of the unions, which include justice, solidarity, pluralism, and non-discrimination and equality that should prevail in how EU law operates. So the crisis, or as we call it, the rule of law crisis, really starts after the financial crisis of 2008, with the election in 2010 of the Hungarian party Fidesz that starts controlling the government after an election, and basically sets its path towards what Prime Minister Orbán calls an illiberal democracy. And 5 years later, the Polish Law and Justice government, elected in 2015, joins a similar path. Basically, the election mandates of these parties allow them to have a strong control of the government, and they seem to follow similar scripts, and they follow this kind of 6 objectives. One is to control the judicial branch. Second, exercising partisan control over the media for party propaganda, controlling and undermining the independence of the civil service, attacking foreign NGOs and human rights organizations in the country, rallying the population against migrants and also religious minorities, including Jews and Muslims. And finally, during the COVID-19 pandemic, they started ruling by decree, which was not only, of course, a kind of usage of these two governments, Poland and Hungary, but they ended up concentrating their powers in the executive, even when they stopped ruling by decree. So what happened with the response of the European Union to all that? Some say the European Union wasn't fully prepared. There was an article in the treaty geared towards the suspension of rights of the member states in case there was a violation or a clear risk of a serious breach of EU values. And this could be triggered by the Commission, the Parliament, or member states, or even a citizens' initiative with a simple one-third majority of the member states. But the key point of this Article 7 is that suspension will not happen unless there was a unanimity vote on the European Council. And so this was hard to happen, or almost impossible, if you have 2 member states out of the 27 member states that would be both in breach of rule of law. So while this political route seemed relevant up to a point, because both Hungary and Poland started with activated Article 7, but of course never got to the suspension of Article 7. First was Poland in 2017 with the Commission activating Article 7, and then later, surprisingly, was Hungary with the European Parliament in September 2008 activating this procedure, but nothing more happened than a very good shaming. This procedure made it the front page of the New York Times when Orban was basically brought to the European Parliament, and the procedure was started in the Parliament, but nothing else. The second kind of response of the European Union was more what we call the rule of law framework and the judicial route. And this route really was reinforced in 2014 when the Commission was really clear that there needed something more was to be done. And especially in the case of Hungary, what the court and the Commission had done was not that effective. And so this idea of the rule of law framework would give more power to the Commission to initiate a conversation with the resistant member states or the violators member states to say, hey, what's going on? And also eventually open up the Article 7 procedure, or even more, bring these cases before the Court of Justice, a case of infringement of the rule of law values. But this tool already existed in the toolkit of the judicial procedures in front of the Court of Justice, because this is a classic what we call infringement procedure, where the Commission can bring a case before the Court of Justice for the violation of some provisions of the treaty by a member state. So what's really interesting is to see the escalation of infringement proceedings that are brought by the Commission, but not like in the case of Hungary, where the Commission brought cases against the retirement age of the Hungarian judges because of discrimination, age discrimination, or the CEU, the violation of free movement of services for basically Orban shutting down the CEU and the Central European University having to move from Budapest to Vienna. But we see with Poland a very different approach by the Court of Justice and the Commission together. And the approach leads to an escalation. So we have an escalation not only in tools used by the Commission and the court, and I'll tell you some briefly, but also an escalation in responses by the Polish government and in its attack to the Polish judiciary. So once in 2016 and 17, the Polish government packs the Constitutional Tribunal, then the National Council of the Judiciary, which is the institution that should supervise the ethics of the legal ethics and the responsibility of the judiciary. Then the Polish legislature passes a law on the Supreme Court and on the retirement age, basically retiring a bunch of judges on the Supreme Court, and then thus having the whole judiciary, higher courts almost packed. The Court of Justice promptly puts out this famous decision called Portuguese Judges. It's an unrelated cases, but this case in 2018 prepares the main judicial tool that says if there is if the domestic courts of a member state are going rogue and are no longer independent, that's a violation also of EU law, because EU law relies not only on a system of EU courts, but also on the domestic courts of the member state. And this allows the Commission to launch several infringement procedures against Poland for various issues, including, of course, the retirement age, but also the judicial independence. There's also the possibility for the Polish Supreme Court that is not happy about the retirement to bring some cases, such as AK and others, to the Court of Justice, that also decides favoring the Polish Supreme Court, saying that the newly created disciplinary chamber by the Polish government is unconstitutional, because it's a disciplinary mechanism that it does not favor the independence of the judiciary. Clearly, this doesn't go well, and as a response, the Polish government passes a muzzle law that in this case limits even more the ability of the judiciary to maintain its independence from the executive. And we see protests, the famous protest of the robes of the judges in Warsaw in 2020. Other interesting tools that the court and the commission use are an interim court order, for which the Court of Justice asks the Polish government to suspend immediately the functioning of the disciplinary chamber and the suspension of the muzzle law. Finally, the commission brings a case against Poland asking for a penalty for the non-compliance with these interim measures of 1 million euros per day from the date of until Poland complies with the decision of the court. In the response, the Polish, as I said, the Polish government is not completely silent. On the contrary, despite the prime minister at the end of 2021 saying that this is a financial blackmail and that he will resort to other means, that we see the judgment of the Constitutional Tribunal, the Polish Constitutional Tribunal, that in October 2021 says something that is kind of pretty incredible and extraordinary for our European legal order, which is that the oversight of the Polish judiciary is not a delegable competence under the Constitution of Poland. Therefore, the Court of Justice decisions and findings are an illegitimate and ultra-virus expansion of power of the European Union vis-a-vis Poland. So we are in full escalation, and we finish with a judgment that we'll talk about today, in which Poland and Hungary decide to challenge the so-called conditionality regulation, which we will talk about. And what's interesting is that both in this action that Poland and Hungary undertake together to annul a European regulation before the court, as well in mobilizing their constitutional court to say the European law is ultra-virus, Poland and Hungary seem to act very much together in their path towards liberal democracy in the European Union.
Fantastic, Fernanda. Very, very comprehensive. I already feel much more knowledgeable about European law than I did just a few minutes ago. Very helpful. I want to see if any of your fellow panelists want to supplement anything that you just said on this point before we move on later to talk about the conditionality regulation. I want to say that I understood a few main points from your comments just now, Fernanda, to include that these challenges from Hungary and Poland have been building up for quite some time, that there's been an escalation in terms of the responses of the European institutions, and then the responses back from Hungary and Poland. And I think I understood that the European responses have largely been ineffectual, at least if the goal is to get Hungary and Poland to change. As I ask, and I will ask maybe Jacinto to speak first about anything he wants to supplement, one aspect that I am curious about, again, as a non-expert observer, is whether or not any of the things we saw out of, say, Germany, that seemed like challenges to some aspects of the European legal order should be part of this conversation, or if they're not, because the nature of the challenge from Hungary and Poland is so different. That's something that I'd love to hear at least someone say something about. But Jacinto, do you want to add a few words?
Yes, yes, thank you. What I would like to add to what Fernanda has just said, and which is really the rule of law is vital for several societies, even more so for the European Union, because among other things, the European Union is based on mutual recognition of rules. That is to say that a rule which is adopted in, say, France or Germany can be recognized under certain conditions, also in Italy and elsewhere. And in this respect, the concerns as to the rule of law in a particular EU country as manifested in the integrity of its judicial system would undermine the trust, the mutual trust, which is a necessary precondition for mutual recognition to operate. So it is really an existential question.
Peter, Francesca, would you like to add anything?
I suppose I would say that obviously part of the picture that you were alluding to is that there's actually a long jurisprudence in Germany that is in tension with some of the more robust understandings of European judicial primacy or even supremacy. And I suppose I'm the right one to talk about it because I've written extensively in defense, frankly, of the German position. But the German position is fundamentally in dialogue with the ECJ, and it's a disagreement over principle, whether or not EU primacy within the scope of authority that is delegated to the EU level gives them so-called competens, that is the competence to determine the scope of their own competence. And that is, I won't say that that's marginal, it's fundamental, but it is a principle that has actually been acknowledged by numerous other high courts in the EU. And if we had Dan Kellerman here, he would robustly argue that that this is the source of all the problems. But that I would say that the German position is one that is operating fundamentally in respect of European processes, that they will only make a determination with regard to the ultimate primacy of the German constitution over the EU treaties in extreme circumstances, both after an exhaustion of remedies at the European level through preliminary reference or otherwise, but also substantively through a series of proportionality and limitations in their own analysis. Now, I know that Fernanda would probably disagree with me on this, maybe, or even Francesca or Giacinto, but I would say that that is a completely different animal than what we're talking about here, because it's fundamentally a question of principle, as opposed to the way in which these political parties have undertaken a program of dismantling in an illiberal fashion, a whole panoply of institutional structures, one of which is judicial independence. In fact, the German position is one that is an expression of judicial independence in some sense, because it's not necessarily a very popular opinion, certainly among German law professors. So that would be my summation of what you were alluding to.
So before we move on, I guess, does Fernanda or Francesca have a different view, or maybe there's commonality on this point?
I don't know if Francesca wants to jump in since she didn't speak yet, or I can say that I agree very much with Peter in terms of I've tried to read whatever translation of the Polish opinion, and which is completely it's very problematic. It's not that clear, coherent. I would say though, even though it's very distinguishable from the German principal approach, as you call it, there is something in the tone, the ultra-virus position, the tone. I think the more recent tone of the German Federal Constitutional Court sounds much more like this. So I would say yes, in principle, in jurisprudence, but the tone is different. And honestly, I think the judges on the German Bundesverfassungsgericht have changed. And so you cannot, even though it was a principal approach from Maastricht, the resistance of the German Constitutional Court to the treaty and to the union for various reasons was a very important principal approach, competence. The tone though of the most recent decisions of the German Constitutional Court, as you said, maybe because I read more the commentaries of Katharina Pisters and other German or American professors, the tone is very infuriating, and I think the Polish Constitutional Tribunal is picking up more on the tone than the substance.
That's fascinating. This is something that I hope maybe we can come back to when we get to the Q&A portion, but let's take a step forward in the discussion now and talk about that conditionality regulation that Fernanda, you alluded to at the end of your initial remarks. Maybe we can go to Francesca now to explain what exactly this conditionality regulation is, how it ties in with the recovery fund that was developed by the European Union institutions after the onset of the pandemic, and how it ties to your understanding of budgeting within the European Union more generally. Francesca.
Yeah, thanks. So this picks up very nicely from Fernanda's account, because essentially what happened when it was seen that the Article 7 TEU process was defective because it required unanimity, and when the frustration emerged from the ordinary case law of the Court of Justice and infringement proceedings that were being brought by the Commission against Poland and Hungary, when all of that emerged, a lot of people began pushing for tying the budget and compliance with the rule of law to getting funds from the budget. And so for that, using the budget as leverage to get compliance on various rule of law reforms, most people thought that it was necessary to pass a specific piece of legislation, and that's what we have now in the conditionality regulation. And so I think this, and it was passed back in December 2020. To understand a little bit more what we're talking about, it is important to understand that, you know, it's not just a random piece of leverage that can be used as a stick to enforce a rule of law. Many people have pointed out that Poland and Hungary, they receive a lot of money from the EU budget. They are net recipients from the budget. And that money is one of the reasons that Orban in Hungary and PiS in Poland have become so successful. As Dan Kellerman puts it, the budget is used to fund autocracy. The EU subsidizes autocracy. And because of the budget, Fidesz and PiS, they're very, very popular, and they're used at the same time to fund cronies and to fund clientelistic networks of voters. And so they're used to consolidate autocratic power in those countries. And the idea is you take the money away and you deflate, to some extent, the autocracy. At least you suspend the money and you hope that there'll be rule of law and you'll deflate autocracy. So returning to the historical background here, back in spring 2018, there was a proposal put on the table for a conditionality regulation, but and the Commission formally put it forward. However, it never went anywhere because it was so politically divisive. Then the COVID crisis. We get the COVID crisis, and what happens? In July 2020, there's a big European Council meeting where the heads of the EU 27, they get together and they commit to a historic COVID recovery fund, which is composed of 750 billion euros, more or less. The figures have changed marginally over time, in the form of outright grants, which is very important, as well as long-term loans. And as part of that, because there was this additional leverage essentially on the table, there was a commitment made to some kind of conditionality. And that was both the leverage that was placed on the backsliders, the democratic backsliders, but also, you know, the net contributors. Germany, France, Italy, which has always been a net contributor to the budget, they have a much bigger incentive for pushing for it when there's that much more taxpayer money on the table that's going to citizens elsewhere. So there was a bigger push for conditionality, and there was agreement, political agreement for conditionality. And then we get all the wrangling in fall of 2020 on the law, because that was political, but now we need to get the legislation on the table. And I should mention that part of this wrangling is not just the 750 billion euros for the recovery fund, but it's the 1 trillion euros for the 7-year budget. The EU has a budget, it's a 7-year budget, and all the negotiations are going on to put together that budget package around 1 trillion euros. So what happens, Poland and Hungary, they backtrack and they say, no, we're not going to sign this. And there are a lot of very upset people in Brussels, really mad. At one point, there was talk of excluding them entirely from the recovery fund. But what happens, eventually they come around, but not without some concessions. And one of the very important concessions that's made on the conditionality regulation, which is passed in December 2020, is that it won't come into force until or at least it won't be applied until the Hungary and Poland have a chance to challenge it in the European Court of Justice, and the Court of Justice issues a ruling where it decides whether or not the regulation is lawful under the higher principles of EU law. And so that's what we've gotten recently in February 2022, which is the ruling of the European Court of Justice, which says it is indeed lawful. And as a result, the Commission has decided to start proceedings. And so it started a proceeding against Hungary in the end of April. There's a letter that was sent out, and it's at the beginning of the procedure. So that's the basic background, and on what the budget has to do with the rule of law, and on the policy that was put into place. On the specifics of the regulation, I think there are a couple things to mention just for purposes of the clarity of the discussion going forward. And so I think it's important to underscore the ways in which the conditionality regulation is novel, it's exceptional. So it sits on top of the budget, which is this 7-year big pot that covers development and agriculture and fishing, etc., as well as COVID recovery. So it's a horizontal measure that sits on top. And each of those pots, those two pots, they have their own rules about corruption, anti-fraud, etc. So they have their own rules, but the conditionality regulation does a couple novel things. First of all, it's not just corruption and fraud, but it's the rule of law more broadly that's covered for getting the money. Second, it does operate horizontally. So once something is proposed under the regulation, payments can be suspended from a variety of development projects, from a variety of agricultural subsidies, etc. And third, it applies early. So oftentimes the most effective time to get leverage is early in the application process that these countries come forward with, in which they want to get the money. And so this can be used to stop approval of the project. It's not applied after the fact when the project is already running and there's some issue with corruption, and so there's a necessary to claw back or at least suspend. It's much more complicated when it's far into a project. And this can be applied early on, and projects can be suspended early on. And so what's the procedure? And this is my last point. There's this back and forth with the Commission, between the member state and the Commission as the first step. And that's where the Commission is with Hungary. The Commission lays out the charges, basically. Hungary gives information, responds. And so that's the first step. Then there's a second step where there's a proposed implementing decision from the Commission, where it lays out the rule of law violation and the pot of money or the different funds that are going to be suspended. And then the third step is a vote in the Council. The EU 27, the members who are meeting in the Council, they get to vote on this for it to become final. And of course, therefore, it's a highly political process. At least, however, it's what we call a qualified majority vote. So there's a veto power by any of the members. Is a qualified majority vote. And so that kind of takes you from the historical background to this concrete piece of legislation that we have now.
Great, Francesca. And we're going to next talk about the European Court of Justice deliberations regarding this conditionality regulation. But before we move on to that stage of the conversation, I want to see if your fellow panelists want to say anything more about the regulation itself. And there's a couple aspects that, again, as a non-expert, I've understood to be potentially interesting. One of them is just the larger politics around the regulation. There seems to be a little bit of a difference between the EU Commission and the EU Council with respect to the regulation, or at least the EU Council seems to have put pressure on the Commission to have the regulation not go into force that soon, and in fact, to wait for the judgment of the ECJ before the regulation could even go into force. I don't know how unusual that is, but I'm curious if others want to say something about that. And then the second thing is that I understand that with respect to this new COVID-related recovery fund, there's a lot of other types of conditionality built into that, which are ways in which national reformers, even in a place like Italy, may use those levers to try to put forward new reforms in those domestic countries because they say it's required by the conditions of the COVID recovery fund. And I want to understand how those conditions are different or the same as the conditionality regulation that is specific to rule of law and has a particular maybe target of Hungary and Poland. Any of the others want to say something about any of this? Fernanda, you seemed very ready to jump in.
I could say something to your first point about this idea, the council compromise, and the idea that these regulation, as Francesca explained very clearly, especially in its procedure, it's a back and forth with the Commission and a vote in the council. And so the council is very much empowered. The council means intergovernmentalism in Europe, and the Commission is more supranationalist. But the Parliament is completely the Parliament, that is the main actor that approves the budget, as the main power to approve the budget from the get-go, is not very much involved in this procedure. And I think if this was very problematic, and that's why the Parliament launched an action too for against the Commission for the non-implementation of this directive, failure to act action, that it's only the second one in the history of the Parliament to ever bring this type of cases before the Court of Justice. I think after, we'll talk about, despite the kind of how much the Parliament was upset before, during its prior president, David Sassoli, right now the Parliament is so focused on another big issue, which is the war in Ukraine, that this is not the focus, and they're happy to pass this kind of big potato to the council. And I just want to say another quick thing, that the Poland and Hungary are not members of the European Public Prosecutor Office, which will be doing, as Francesca was saying, an ex post analysis of the corruption of this funding. So because they are not, there's really much more need of this ex ante check on whether the funds are, spent in a system that will prevent corruption and cronyism and all that.
Great. Jacinto, maybe you can speak especially to that second point of how the conditionality of this rule of law, conditionality regulation, is the same or different from the conditionality that goes with the COVID recovery funds generally, that, as I know we've discussed, maybe the technocratic elite in countries like Italy may be using to push forward some of their reforms.
Yes, Nathan, it is always important in a legal discussion to make distinctions. One thing is to say that there's a conditionality in the sense that the European Union gives money through the recovery fund, as Francesca has just said, in order to achieve certain goals which have been agreed. So just to make an example in which I have been personally involved, there is money for the reform of the Italian system of justice, which has several drawbacks. And that means that the conditionality regards the purposes or the content of the things that have to be done. Another thing is to say that there's conditionality as far as the ways in which functions and powers can be discharged by public authorities. And that is the perspective from which the EU regulation on conditionality becomes so important and controversial.
Great. And before asking Peter if he wants to say something, I want to note that one of the tremendous experts in our audience, Kim Shepley from Princeton, is adding some very useful comments in the Q&A. I'm not sure if the entire webinar can see that. So if there's anyone who has the capacity to make both of Professor Shepley's interventions publicly viewable, that would be wonderful. And I will read at least the second one out now, because it's directly tied to the conversation we're having now, and maybe Peter, who can see it as well, I think, can maybe say something about that. So Professor Shepley writes, on the regulation itself, the conditionality regulation, while the, quote, rule of law is still in the text, the requirement that the rule of law offenses have a direct effect on the budget means that in practice, it has been reduced to an anti-corruption tool. For example, the Commission has been hinting that attacks on judicial independence don't have a strong enough effect on the budget, but instead the Commission is leaning into things like corruption in public procurement rules and management. So Peter, let me see if you want to add something, including maybe in response to Kim's point there.
Well, so both of Kim's points are excellent. She also chimed in earlier on the question of tone, tracing it potentially to the Court of Justice of the European Union, and that perhaps the Bundesverfassungsgericht, the German Federal Constitutional Court, was reacting to their dissing, as she puts it. Both of her points are really excellent. And I guess, you know, I'm tempted to take a step back here because, I mean, this is a program, this is the PEN program on regulation. And so obviously it's deeply concerned with norms that are produced by a specific kind of actor, an administrative actor. And we distinguish administrative actors from constitutional actors. So we know that administrators can make rules, they can enforce rules, they can adjudicate disputes, but those are subject to the oversight of robustly legitimated constitutional bodies. And I think that operating in the background here is this question of what the EU actually is. Is it an autonomous constitutional entity of its own? It certainly is a vehicle for expressing constitutional values, but is it autonomously constitutional in itself? And this goes to the heart of the dispute between the German Federal Constitutional Court and the European Court of Justice. The ECJ sees itself as fundamentally a constitutional court sitting at the summit of a community, a constitutional community committed to the rule of law and democracy. Whereas the court says, no, those are important values and we're glad you're committed to them, but you really are sub-constitutional with regard to us, with regard to all other apex courts, and with regard to all other national constitutions. Now that idea was seized on, I thoroughly agree with Fernanda in an opinion that is actually hard to understand. That was seized on by the Polish, the remade, and many would regard, and I would agree, currently illegitimate Polish Constitutional Court. That idea was seized on in order to advance the PIS agenda of complete judicial subordination to the party, to the executive, and to the parliamentary majority that it holds. So with regard to Kim's point, and Kim is chiming in again, but with regard to Kim's point, with regard to the regulation, the narrowing of the regulation is something that if we begin to appreciate the EU in administrative law terms as a regulatory actor and not as a robustly legitimated, autonomously constitutional actor, the ways in which the political actors, and particularly Germany, in sort of reviving but changing this proposal that the Commission had sitting around, this rule of law conditionality regulation, and turned it into something much more narrow. As Francesca rightly said, it sits atop these two buckets, but it also sits atop a relatively complex regime of financial protection, if you will, protection of the EU budget as it's distributed out. And so this raises all sorts of issues about, one, the power of the EU to monitor those funds going outward, What kind of nexus do you need to have between the misuse of the money and the EU budget? So it's not a generalized rule of law instrument. It is an instrument for the protection of the EU budget. And some would say that it's fundamentally an anti-corruption tool, and as such, not a major step. I actually disagree with that, and I rarely disagree with Kim. Well, Kim and I do disagree, but I actually see this as a very constitutionalizing step in the sense that I would use that term. That, the idea that you can't be just a little bit pregnant. If you're giving money to an individual member state, and you can say, well, if you're using the money for EU purposes, you have to be independent, but if you're using it for national purposes, you don't have to be independent. Well, money is fungible, and that's drawing those lines are really hard. And so the three elements that they demand in terms of monitoring, in terms of robust prosecution or enforcement, and in terms of independent judicial review, those are the three elements of the rule of law that the regulation seizes on and seeks to enforce. That's going to have, given the nature of money and given the scale of mobilization in the COVID response, this is going to have pervasive consequences within the member states, and it's going to serve as some real leverage. And it's not surprising that this is tied to money, because money, the autonomous capacity to mobilize fiscal and human resources really is the essence of constitutional power. And this is something that the EU has largely, not entirely, but largely lacked, certainly not at a constitutional scale. And for that reason, I think that lurking in the background of this entire discussion is a very fundamental question about the nature of the EU.
I think someone wanted to, did someone want to say something just now?
I just wanted
Francesca, yeah.
It's always bad to play devil's advocate when the advocate on the other side is Kim and Peter and Fernanda, but I having read this goes back to the issue of what are these different kinds of conditionality, and what's the conditionality in the recovery fund program and facility that's there. I went back and I read the draft implementing decision for Poland's plan that was just issued. So what happened was Poland has submitted a plan to get its 35 billion euros in recovery money from the program, from the facility, and the Commission has just given its initial approval. And there's conditionality having to do with rule of law, and there it all has to be tied to investment climate, corruption, fraud. But the kinds of actual things that they ask from the Polish government are things that go to this cross-cutting reform of the judiciary. We can talk more about what this cross-cutting reform of the judiciary is, but it really goes to removing some of the most objectionable things that are out in the system currently that impedes judicial independence. Now, there's a lot of commentary out there saying the Commission went too easy, but it is true that before the tranches of funding are released, and the so-called milestones have to be reviewed. And those milestones have to be reviewed by the European Commission in conjunction with the Council and the Special Committee, with the European Parliament involved, because fortunately, since this is a regulation, all the normal treaty procedures operate. And so the European Parliament is involved in this so-called comitology procedure too, before the funding can be released. And so I just don't want, I wanted to simply say that I think that a lot can be done under the umbrella of improving the investment climate and making sure there isn't fraud and corruption.
Very, very helpful. We could definitely keep lingering on this part of the conversation, but I do want to get the European Court of Justice into the picture as well. I will note that we're seeing a number of very additional helpful comments from Professor Shepley, and so I will just suggest that we have all of those also be put into the chat as we're going along. So we have sort of an unofficial fifth panelist as we go along commenting. These are all very, very helpful interventions. But let's talk about the European Court of Justice now. Again, this was set up, as I understand it, the conditionality regulation, so that it would not go into force until the the European Court of Justice ruled on it, and it took a action by the European Parliament to finally get the European Court of Justice to rule on it. Maybe Jacinto, you can tell us about how the court, once the case got to it, and if you want, you could even say something about how it took a process to get to the court. How did the court actually rule, and what did you discern in the logic of the court's ruling, especially as it related to how it handled arguments from Hungary and Poland?
Thank you, Nathan. I guess that the main point that I want to make is very closely related to the final point made by Peter, but it's to say this is a landmark constitutional case. And three aspects could be considered for highlighting its importance. First, the process. Secondly, the grounds on which both Hungary and Poland complained about the regulation. And thirdly, more importantly, what the court really said in its judgment, and why it gives only very limited support to those claims. Now, first of all, this is a very important judgment, not only for substantive reasons, which have already been mentioned in our previous discussion, but also for formal and procedural reasons. So not only this is one of the many cases in which the decision of the court has been preceded by the opinion of the Advocate General, which has an advisory role, but more importantly, this was decided by the court as a full court. And the Court of Justice may see it as a full court only in the cases which are prescribed by its statute, or where the court itself considered that a case is of exceptional importance. So not simply one of the many important cases that reach the court every year, but this is of extraordinary importance. Finally, this is one of those few cases in which many member states have intervened in favor of the European Parliament and the Commission. There were 10 member states, including France and Germany. So in a way, from a political point of view, you could see that there were Hungary and Poland on the one hand, but there were 10 member states, including France and Germany, on the other hand. Now, coming to the second important element for a better understanding of this landmark constitutional case, what did Hungary and Poland complain about? Now, they used some arguments which are very often used when the member states go to the court. So first of all, the absence of an appropriate legal basis, which is important because the European Union is a system with limited or enumerated normative powers. And then they added that the European Union had exceeded its powers. But then there are two arguments which give us the flavor of a constitutional case. That is to say that the European Union institutions had circumvented the procedure laid down by Article 7, the procedure which Fernanda has already examined initially. And plus, they also complained about the breach of the principle of legal certainty. And Poland in particular vehemently argued that the European Commission would be able to make arbitrary decisions, and some supporters of this position went up to the point of asserting that the Commission would blackmail single member states. So it's important to understand that the Court of Justice rejected all these arguments. So first of all, it rejected the argument based on the lack of an appropriate legal basis, arguing that this regulation, as Francesca just said, is of fundamental importance for protecting the budget. And interestingly, in one of those obiter dicta, which are so common in the judicial decisions of the Court of Justice, they added that financial rules may do many things, including regulating a mechanism of conditionality. So they wanted to make it clear also for future purposes. And then they went on to say that there is no circumvention of the fundamental procedure laid down by Article 7, the mechanism which is specifically used to protect the values of the European Union, because in the Court's opinion, these are two different procedures. One is to protect the values contained in Article 2, including the rule of law, while this procedure serves in order to protect the financial interests of the European Union. So they are related but distinct. Now, thirdly, coming to what is perhaps the most salient political element of this judgment, the Court of Justice rejected the argument based on lack of powers, and it argued that the values contained in Article 2 have been accepted and shared by the member states, and they define, quoting from the judgment, the very identity of the European Union as a common legal order. So in a way, the court is emphasizing the importance of those values. And finally, with regard to the principle of legal certainty, interestingly, the court said, well, but you already knew that the rule of law, the principle of legality and judicial independence were important, because I myself, the court, in many previous judgments, have already defined and refined those general principles. So these can be regarded as being known by all the member states. Now, so what remains? What remains of the claims brought by Hungary and Poland? I would say that there are two elements which we may want to consider in the next stage of our discussion. On the one hand, the court conceded from a rhetorical point of view, but we know that in law, rhetorical arguments are not deprived of practical importance, that the member states have separate national identities inherent in their fundamental structures. So in a way, it declined the main argument, but it accepted the minor side of that argument, in the sense that even though those values are shared, there can be differences. Now, clearly, the balance between what is shared and what is different deserves further consideration. And finally, the court emphasized the necessity that both the Commission and Council respect the procedural requirements, the specific procedural requirements that have been laid down with regard to the assessment of the respect of the rule of law.
That's fascinating on so many different levels, and I'm sure the others will want to say things about a lot of the analysis that you just laid out, Giacinto, but an aspect that I especially hope that we can focus on is what you just ended with, this question of how do we define the rule of law? Now I get to bring in some of my China expertise. Of course, that's a very hard question. And it reminds me also of your project, Giacinto, on the common core of European administrative law. Is there a common core of rule of law that Europeans can all agree on? And if not, isn't there some challenges here? Peter or Francesca, Fernanda, do you want to say anything about that element or anything else about the ECJ's decision in this case? Fernanda, go ahead.
I can say something briefly, and I also been reading Kim's contributions to our conversation, and she highlighted a piece by Wojciech Sarduski that also talks about this paragraph that Giacinto, when you were talking about the main political take of this question as this rule of law is really the identity, but to me, the court in this paragraph that Wojciech really mentions prominently too, it's paragraph 148 that really connects this idea of rule of law with this idea of efficient implementation of the union budget according to sound financial management, saying that because the budget is a product of our solidarity, and whatever goes into this budget that Francesca described, and this big budget, it needs to be redistributed in a way that it needs to be efficient, with sound financial management, protection of financial interest, and all that. That's where the rule of law is connected. That's the hook. I don't think it's a super strong hook, but it's there, and that's why the idea of connecting this very vague notion of rule of law, because we saw even in the judicial independence, as Giacinto was saying, the Polish and the Hungarian court were trying to say, well, the way we structure our national judiciary, we want leeway from whatever the union sees as judicial independence, because you're looking into our judicial structure very closely. So, and we all know that it was kind of a pretty problematic judicial structure fake, but I think the argument of saying, what is this sound financial management and protection of financial interest? How does it tie to the rule of law? And what is the leeway that each member state has to do so? When it's, of course, out blunt corruption or packing of courts, or it's pretty, but where are the parameters of that balancing them? Giacinto mentioned, but I also wanted to put out there that the tie between rule of law and financial management.
And I'll note, before seeing if Peter or Francesca wants to weigh in, that Kim has put in maybe we can again show the rest of the audience that Kim has put the definition of the rule of law from the conditionality regulation. And I'll let others consider whether that's something that is enough, or if, again, this is the kind of thing that we could debate how specific accurate this is in some kind of ideal sense of what we think the rule of law is. Peter, go ahead.
Well, I mean, I think part of what's going on here is another line that we're very familiar with within administrative law, and that's the line between law and politics. And also, I think operating in the background here might be a distinction between a kind of Rechtsstaat mentality, the legal state, and the rule of law, which I think tolerates a little bit more ambiguity and discretion and guidance documents as a way of shaping administrative action. All of this is implicated here, but as between the line between law and politics, I mean, the argument that the Parliament made, that Fernando alluded to earlier, that they were taking an action against the Commission and Council for failure to act. Well, that makes an assumption that there's very little margin of appreciation. There's very little discretion. That in some sense the mechanism, and it's not a rule of law mechanism. And I mean, Kim has written with John Warren, and John has been very clear on this. This is not a rule of law mechanism. It talks about certain features of the rule of law as it relates to the budget, but it is not a generalized rule of law mechanism. And that was an essential change made to the regulation in order to differentiate it from Article 7, because they would have been in a lot more trouble with the court had it been a comprehensive rule of law regulation in the way that some people still aspire it to be. And so we can, there's sound principles for why they backtracked in law, but about strategic law, about the line between law and politics. And then also the idea that they were going to allow the Commission to develop guidelines. Well, from an American administrative lawyer standpoint, that's not very problematic to give guidance to potential targets of enforcement about what their enforcement policies are and how they're going to go about exercising their discretion. What it does is it actually shapes the discretion and makes it more definitive. And they allude to all the things that they're going to take into consideration, not least decisions of the European Court of Justice. So there is a kind of Rechtsstaat mentality that sees the administrative actor as somewhat ministerial, not with a great margin of appreciation, that must act pursuant to legal obligations, even if those legal obligations are actually sometimes necessarily ambiguous, and through that ambiguity necessarily delegating some measure of policymaking authority. So I guess that would be my response. And we should, I mean, this is an important comparative point that we'll be talking about a lot more, I think, on Friday.
Exactly. I was just thinking how happy I am that we're going to get to see each other in a few days here on campus. Francesca, do you want to say anything on this point before we move on to the next segment?
Yeah, well, I think it ties actually nicely into our comparative administrative law discussion, because, you know, budget is kind of at the core of what administrative law does, right? And so if you shift the focus to budget, then like, what's the rule of law in the context of the budget? And I do think that historically there's been a big divide between what, you know, Peter talks about with the Rechtsstaat, where the idea is that everything has to be governed by rules that are set down and in a recognizable and public set of sources. And that's extraordinarily important. They have to be complied with. And then, and this is the common law contribution, everything that is done has to be tested in front of an independent judicial forum, in an independent court. And indeed, you know, that's all Dicey's notion of the rule of law. That's really all about being able to get yourself into court in an ordinary court, which is by definition independent of the powers that be, to test what's been done. And that's the reason why, you know, he always criticized the French as being a rule of law, because they had this Conseil d'Etat, which was inextricably linked to the executive branch. And so I do think here you see a lot of emphasis on the idea you have to be able to go into court in an independent forum to be able to test all the funding decisions that are being met. And if there isn't that independent forum, then we don't have rule of law and there's a breach.
Fantastic. So we've had three segments, main segments for our conversation so far. We've started sort of at the realm of broad politics, the kinds of challenges that emerged from Hungary and Poland, and we moved to the policy response of the European institutions, and in particular, this conditionality regulation. Now we've been talking about the European Court of Justice's decision, and we've now gone down into the weeds of thinking about the meaning of the rule of law. For our last segment here, before we really want to encourage as many people in the audience who want to raise questions through the Q&A function, we just want to go back, I think, to broad politics, and in particular, look at how that picture has changed since the European Court of Justice's opinion in February. Of course, an intervening event since then has been the war in Ukraine, which has had lots of ramifications for much of the story we've been discussing here. Maybe Peter, if you want to say a few words about that, we'll wrap up our conversation here after that. And then again, please, anyone in the audience who wants to ask questions, please put them in the Q&A and we'll get to as many of them as we can. Peter.
So yeah, one of the things I could talk about here is, you know, coming back to the strategic alliance, if you will, at least within the confines of European integration, the strategic alliance between the Law and Justice Party, the PIS in Poland, and Fidesz, and their control since 2010 in Hungary. And the strategic alliance, you know, flows significantly. It's not just sort of substantive overlap, though there's some significant differences in their populism, I should say. I mean, one would say that not only is Orban a populist, but he's very much into a kind of crony political economy that has been used in order to reinforce his power. And while there's been certainly some of that in Poland, Poland has done a much more frontal attack on European values, at least with regard to judicial independence, but it hasn't done a lot of those other things. And in some ways, the Polish problem is more easily solved, and I'm going to be talking about that in a moment. But getting back to this strategic alliance, the bottom line is under this Article 7 that we've alluded to a lot. This is the generalized rule of law policing mechanism, if you will. it doesn't lead to expulsion of a member state, but it does lead to their suspension of voting rights within the council, which is really important in the key intergovernmental body. And the bottom line is that if you have a proceeding commenced against you under Article 7, you can no longer vote in your own case. All right, so obviously you can't veto an action against yourself, meaning a country. But if you have one other country that is also in the crosshairs potentially of an Article 7 procedure, they can veto for you. And so we have this mutual veto that's been going on that's completely neutered and sidelined the Article 7 procedure, and hence raised the importance of these alternative mechanisms. Well, that strategic alliance is under serious strain as a consequence of the war in Ukraine. So the big decision of the Court of Justice happens on February 16th. 8 days later, Russia decides to invade Ukraine. And Poland is, robustly behind Ukraine and very anti-Putin, and has been extraordinarily generous in contrast to what was doing in sort of mid-decade with regard to non-European migrants. It has been extraordinarily welcoming and generous with regard to Ukrainian refugees. And this is something, in the lead up, the tensions leading up to the war, they were just a huge supporter of the Zelensky government and very critical of Russia. I mean, the de facto leader of Poland, Kaczynski, blames Putin, attributes the death of his brother in a plane crash when he was president of Poland, to Russia. So there's just huge anti-Russian sentiment in Poland. And you would think that maybe you would see some of that in Hungary as well. And one of the first speeches that Orban ever gave as a political figure in 1989 was very anti-Russian, harking back to the Prague Spring, or not even the Prague Spring, but all the way back to the '56 uprising. But more recently, he's quite changed his tune, and as sort of sticking it in the eye of the Ukrainians, in early February, he made a visit to Putin in order to want to expand a contract that had only been entered into the prior fall, and he wanted to expand gas supplies from Russia to Hungary, and he also talked about perhaps creating a manufacturing facility for the Russian COVID vaccine, et cetera. So this visit is a sort of, I'm not saying it's everything, but it captures a kind of the difference in sensibility between the Polish leadership and the Hungarian leadership. And the visit was absolutely slammed by the Ukrainian leadership as just completely disrespectful of their position. Now, then on the 16th, we get the ruling on the conditionality mechanism, that it had a sound legal basis in Article 322, that it had sufficient legal certainty. Russia then invades Ukraine on the 24th. On March 2nd, the Commission issues its guidelines. If there's a serious breach of the rule of law principles with regard to monitoring, enforcement, judicial review, and that is attributable to public authorities, and it seriously affects the EU budget, all of which are requirements within the regulation itself, then the Commission would take action. Well, as things proceed, obviously the war is going on. Orban has an election. Hungary has an election, and Orban and Fidesz once again is returned with a parliamentary supermajority, a constitutional majority sufficient to basically allow them to do whatever they want. And this has been one of the problems, frankly, and this is where Kim needs to be here, because she could give the litany up and down. But what happens in 2 days later? 2 days later, the Commission announces that it is in fact going to trigger the budgetary conditionality mechanism based on these rule of law values against Hungary. And so, the commission had been quite cool to Hungary, stretching all the way back into 2021. They had made it clear that this is not, that they had deep concerns about the request that Hungary was making for these COVID relief funds. But what happens at the same time is that Kaczynski does an interview in which he slams Orban personally and Fidesz, and basically say, unless they change with regard to Ukraine and with regard to their attitudes toward Putin, we can't cooperate with them anymore. So here we get the sense of this strategic alliance breaking down. And so the commission is sort of seizing on this dynamic, that they see, out of, a genuine sense of gratitude and admiration for what Poland is doing with regard to Ukrainian refugees, but also perhaps as a way of driving a wedge. So, European Commissioner visits Warsaw and lauds the Poland. This is just in late March. The President of the United States visits Poland in late March and lauds their role with regard to Ukraine. And so all of that sort of creates the atmospherics for a fundamental change. So on the one hand, we have the commission, and they may well use the document that was written by Kim and Dan Kellerman and John Moran, spelling out why the EU should, in fact, not distribute funds under the COVID relief mechanism to Hungary, excuse me. And frankly, it might lay the basis for a more even generalized attack on funding to Hungary. But what happens on June 1st? And this is another thing that probably I would disagree with Kim. The European Commission endorses the Polish request, the Polish, what they call, resilience and recovery plan under this next generation EU mechanism. And this is going to be $36 billion that are going to be infused into the Polish budget. Now they endorse it, but they endorse it subject to conditions. The conditions are these milestones with regard to eliminating some, but hardly all, of the mechanisms or institutional features, most importantly, what they call the disciplinary chamber, that had been established by the PIS government in order to discipline judges, not because of their behavior, but for the content of their actual judicial decisions. It goes to the heart of judicial independence. And there's been, I don't know the exact numbers of people who have actually been disciplined. It's something in excess of 10. But people have lost pay, they've lost positions. And so the commission wants to see this chamber eliminated. Now, is it going to be eliminated is the big problem here. There is a bill that was originally introduced by the President Duda, the President of Poland, that in effect simply changed the name of the disciplinary chamber, but really in substance didn't change what it would achieve. And I'm not going to get into the details of that, but the bill, and this is where you have a much different political situation internally in Poland. While PIS has a majority within the lower house, and the lower house ultimately calls the shots, the bill has to go up to the Senate, where there is a bare majority of the opposition. And within the confines of the substantive confines of the bill, the Senate can offer amendments, and they offered quite significant amendments to try to, very substantially comply ultimately with the milestones that were requested by the European Commission. Now, one of the critiques of what the Commission did on the first is that they endorsed the recovery plan for Poland right in the middle of this process. And so Wojciech Sierzurski said, this is terrible because they've given up all their leverage. I don't buy that. I think that they're making a strategic play to try to reinforce what they see as an emergent pragmatist current within the PIS who will perhaps back some of, if not all, of the amendments that were put in by the Senate, so that when it goes back to the lower house, that it might pass through, as opposed to having the bill be restored to the original version, which was merely cosmetic in its changes. So we have this whole deep political process going on right now, and there's a lot of ambiguity. There's a lot of strategic action going on. It is not straightforwardly law, no doubt about it. But van der Leyen made a trip. She's the president of the European Commission, which is the head of the European executive branch, if you will, in which to in some sense celebrate and mark the moment that the Commission had endorsed this request under the Next Generation EU mechanism. But she also noted that we're not at the end of the road, that before the end of the second quarter of 2022, they have to satisfactorily meet these milestones. So that's where we find ourselves. Will they satisfactorily meet the milestones? I think from the hardcore kind of purist sort of Rechtsstaat mindset, they won't be able to do enough unless they completely dismantle it entirely and restore the status quo. The Commission seems to be willing to accept maybe not half a loaf, hopefully maybe 3/4 of a loaf, but they're going to be trying to do something here. And this is all in the shadow of geopolitics. And the final thing to talk about here is with regard to Russian sanctions coming out of the EU. The EU has voted most recently the 6th package of Russia sanctions. And despite some appearances, I mean, Hungary has been pushing back on certain things, but they were able to get through a Russian oil embargo, but accepting Hungary and Slovakia and Czechoslovakia, which receive their oil via land, they're landlocked, so they don't have opportunities to get it from other places. This is something that Hungary fought for. So they're basically going to get a 90% embargo. And so, yes, the bickering continues, the messy politics continues within the confines of an extraordinarily complex institutional system. But where we stand today is relative unity, but with Hungary still being a thorn in the side, at least geopolitically, vis-a-vis the challenge of the Russian invasion. But you have a conditionality mechanism that I think has tremendous possibilities. And I would say, and this is me saying this, which is quite extraordinary, constitutionalizing possibilities with regard to an interplay between a more robustly legitimated level at the EU level and the historically strongly robustly constitutionally legitimated bodies at the state at the member state level. I think that there's been a fundamental change, and I think the dynamic, the functional attractiveness of collective borrowing, the open information channels that this creates, the enforcement mechanisms, creates a federalizing dynamic. And I mean that two constitutional entities interacting with each other that is in germ, not unlike what we see in the United States, where 30% of the budgets at the state level in the United States come from the federal government, not with generalized rule of law conditionality, but with lots and lots and lots of conditionality, compliance obligations. And in some sense, what the conditionality mechanism has created is a kind of going to be a kind of compliance process that is going to lead to a very different, I think, relationship, one that steps outside of law, outside of the Rechtsstaat mentality, and gets more into something that is recognizably regulatory federalism as we would understand it in the United States.
Wow, that is interesting, and it veered into a very optimistic direction at the end, which I wasn't anticipating. So that that I find quite interesting. there is no possible way we're going to be able to wrap up all of these threads in the next 6 minutes before we conclude. I think if we can do just two things in the next 6 minutes, I want to ask the other three to weigh in a little bit, again, with very little time, on what Peter just said, and I'll pose a particular framing for that. And then there's at least one excellent question in the Q&A that I want to pose to all of you. We have very little time, so let me go very quickly. So the first thing, again, to see if the others want to say something about that, and the shorthand, I think, is if leading into the conditionality regulation, Hungary and Poland were in the same basket, now they're in two different baskets. And what does that imply for the conditionality regulation if it starts being applied differently vis-a-vis these two different countries?
Careful on, I mean, their strategic alliance remains, but it's under stress because it would be a nuclear move on the part of Poland to say that they're no longer going to veto an Article 7 proceeding against.
But at least, as you said, it seems as the
but it's not out of the question.
institutions are interested in working with Poland in a way that maybe is less evident.
No doubt about it.
Okay, Giacinto, Fernanda, Francesca, 30 seconds each. What do you want to add on this point?
Very quickly, Peter already said it. I just want to put some more emphasis on this. For the use of money, the capacity to mobilize resources is of vital importance for every constitutional structure. What is changing with the new recovery fund is that the European Commission has been authorized to go on financial markets and borrow money. So there is not only the loans that are given by the Union to the member states, but the Union itself can break what was regarded as a taboo. And by the way, the reaction of financial markets has been very positive. So there is more than simply a potentiality of a new phase of constitutional development.
And you know, Fernanda and Francesca, in inviting you to weigh in, I'm just going to read the question that came in because maybe you can incorporate that into whatever your closing comments are. Oh gosh, now we have another excellent question. I'm going to read both of them. I'm going to read both of the questions to have them on the table and then see, Francesca and Fernanda, what you want to say. So the first one from Amit Ashkenazi, wonderful discussion. What if the conflict was framed not in administrative law, but as a more simplistic breach of, simplistic in quotes, simplistic breach of public international trade law obligations between sovereign states, as mentioned by Professor Della Cananea, in the sense that the rule of law, anti-corruption, and the independence of the judiciary support trade relations and go to the core of the European single market, the free flow of goods and services. That's from Amit. And then from Alicia De Monte, given that the connection between benefits and convergence towards rule of law standards has informed the pre-accession conditionality ex-Copenhagen criteria, that may be EU lingo that I'm not familiar with, could it be that the current conditionalities establishing the country's membership to the EU is a matter of performance? That's fascinating. And then I'll just read also Kim, again, thank you, Kim, for all these wonderful comments as our unofficial fifth panelist. Excellent session, everyone. Oh, it's just very nice. That it's fascinating to listen to those of you who have not been the weeds from this from the beginning. She has lots of new ideas from it. Okay, so why don't we do Francesca, Fernanda, and if we can go 5 minutes over, also let Peter and Giacinto say a final word. Francesca, why don't you go first?
Okay, thank you. Thank you for those excellent questions too. So the first one, I think it's absolutely true that the rule of law is something that is horizontal, meaning it goes to the whole common market too. And so we've been talking about the administrative dimension with the budget, but it's, of course, it goes to premium goods, services, people. And the EU can't exist unless it has the rule of law, meaning, you know, transparent, equally applicable rules that are enforced by independent courts to which individuals have a right of recourse. And that's, I think, essentially what's being suggested here. And I think that's absolutely why, you know, from the very beginning in the Article 19 ruling that Fernanda talked about in Portuguese judges, the court has been extraordinarily insistent on that point. And it's something that I think we historically tend to forget because we got that basically in the 19th century, in the long run up to the, you know, the First and Second World Wars. We got a set of courts that were free, independent, and enforced basic liberal values. which at the time was more towards the market. But anyway, so I think that's a nice way of putting it. And I think that rule of law really does have to, extends across every dimension of the treaties. And just into my concluding thought, I think that, the Commission and the EU, they have so many balls in the air when it comes to constitutionalizing this entity. Because, and I hope they can manage them all, but that the real problem is that they are faced with crises on every possible frontier now. So they have the rule of law, they have the Russian invasion, they have Brexit that's still going on, with the UK trying to pick off the Eastern countries and like inviting Ukraine to join it in some kind of special relationship. So there are multiple things going on that it has to kind of juggle, and it wasn't very good at doing that during the Euro crisis. The Euro crisis, one of the reasons we got the rule of law crisis, because they had to ignore Orban for a long time. So I'm just hoping that they can keep all the balls in the air together.
Excellent. Fernanda, again, keeping in mind we're over time now, so
Okay,
your
just 2
closing
points
comments here.
On Ahmed, the first question, I would say the international trade law framework that the court tries to use in the decision on the Central University, European University, brings to no results whatsoever, because CEU has to move to Vienna, and so there's no consequences, whereas this new rule of law kind of enforcement conditionality could really bring to some results for the rule of law. For Alessia, I think she makes a big point about political economy. We didn't really touch upon it in this panel, but just let me say that Peter talked about Orban winning the elections. And there's now good commentaries on the New Left Review, for instance, about the type of political economy. Francesca wrote a book on EU law in populist time, and the discontent with the European Union system, very much driven by a neoliberal framework, especially by the Commission. And so the question is whether these conditionalities will be really give a tool for the Commission to again impose the straitjacket of the kind of admission criteria, even of the 90s, or impose certain fiscal regime and fiscal rigor in a kind of Washington consensus way, or whether these conditionalities with the rule of law will now, in a post-COVID scenario with lots of post-populist, and one of the success of Orban in its election has been that he's kept the prices of gas down. He has enriched the Catholic middle class, and it has done things that, when we say for the US elections, Biden has to lower these gas prices, otherwise nobody's gonna buy. So if Orban has the budget to do it because of his alliance with Putin, will the Commission, the European Union, really manage to do that kind of financing, which Giacinto was talking about, by issuing Eurobond, will then fuel a more robust European economy that is not based on kind of neoliberal Washington consensus criteria, but much more redistributive, egalitarian, sustainable green Europe.
Excellent. Peter, Giacinto, you both get 2 sentences to close before we wrap up here. Peter, do you want to go first?
I'll just say thank you. Thank you, Nathan. Thank you, Carrie. Thank you, the whole team at Penn. Thank you, my fellow panelists. I look forward to seeing you on Friday. And thank you to all the attendees. I wish I had a better sense of how many of you were out there, but thank you especially to Kim Shepley for, always her provocative interventions and her command of both the facts and the law.
Absolutely. Wonderful. And Giacinto?
Thank you so much. Also from my side, what I want to say, just to conclude, is that we had 2 dimensions in our discussion today: the dimension of policies and the dimension of institutions. What we are witnessing is not simply a change in policies. There's a huge difference with the response to the economic crisis of 2009. Here we're witnessing a change concerning institutions. And in that respect, Peter and Francesca and Fernanda's points about the new constitutional dimension deserves further consideration. Thank you very much.
Fantastic. I can't possibly improve on the eloquence of Peter's closing just now. I'll just repeat exactly what he said. I endorse it all. Especially thank you to Carrie and the Penn Program on Regulation for hosting our conversation today and letting us use their platform for what I have just learned so much. And I'm so grateful to all of you panelists for joining, and the wonderful audience that has been in the room today. I wish we could keep the conversation going, but we'll put a pin in it for now and find different venues to keep it going elsewhere. Thank you all, and that's it for today. Good night.